Innovation Council. We have covered we have covered the introduction of IPR and criteria of patentability in the first session. So now we are moving to session 2 where our eminent speaker will be covering couple of topics. The first topic is content and drafting of patent application and the other topic is IP management for startup. So I welcome and introduced our guest speaker of session 2, Dr. Anil Turukmane. So here is his introduction. He have completed his postdoc in computer science and engineering from Lincoln University, Malaysia, 2021. He have completed his PhD in computer science and engineering in the year 2016. With this, I uh, want to share that his journal publications are in SCI and Scopus English journals. The number is very big actually, it is 34. And along with this, he have published his papers in the 14 conferences. He have published 20 patents and got the fund sanctioned for two FDPs. The first FDP is AICT Atal and the second is from the Batu Loan area. He have published 6 books and 3 book chapter. He is editor of 6 different journals. He has been awarded with 7 awards. The list is also big, and he is the professional membership of 6 professional bodies. So here is the brief introduction of our eminent speaker, Dr. Anil Turukmane. So I welcome you, sir, uh, to enlighten with your information with us so that we will get the benefit from that.
Yeah,
Yes, you can share your screen.
yeah. Thank you, ma'am.
Yes, sir.
My screen is visible to all.
Yes, sir. Your screen is visible. Only the thing is you have to share this slideshow.
Now it's visible, ma'am.
Yes, sir. It is visible.
Yeah. Good afternoon, one and all present here. And first, I want to know about all are these are the faculty or student also with this FDP?
All are faculty. Sir.
Faculty. Okay, okay. Thank you, ma'am. Yeah. Okay. Good afternoon, one and all. Today, FDP session topic that is drafting a patent specification, patent open examination and practices. Okay, earlier 2 sessions there is conducted some of the introduction with part of that patent. Can anybody tell me what actually the patent? What idea actually you got from the first 2 session?
If we have any innovative idea or some novelty,
Okay,
then we can go for filing patent.
okay, okay, good. Um, Yeah, see here, first scope of that particular patent, just like some of the questions for you. First, suppose anyone want to, just like for the faculty members, anyone want to submit their patent in Indian patent, otherwise the any other country patent. First, you need to know about that. What is that scope of patent? Just like for some of the questions, what is a patent? What is patentability? What is not patentable? Precaution to be taken before the drafting specifications, content of specifications, claim and their interpretations, examination practice, PCT and body paste treaty. These are the some point in your mind. We will see one by one what actually that and how you are drafting your patent in uh, nicely in Indian Patent Office or other patent offices. Now see, just like I shortly introduce again some definition and some basic of that. Patent that is a limited monopoly rights to confirm by the state of consideration of disclosure of the invention. Just like see, in particular patent, suppose in patent having different parts, just like for suppose anyone want to for inventions, new product, anyone want to for design, anyone want to for particular source code, that source code they want to for the copyright that particular is different part in your patent. Just like a normally definition given is just like a monopoly rights confirmed by the state of consideration of disclosure of inventions. Now see, in that particular patent, some of the given solutions or invention, just like sometimes what happen in our engineering colleges and universities, some of the students doing their projects and some of the research work, they find out some of the unsolved problem solutions. Those are problem having unsolved, they find out that solution and they need to be to patent that particular solutions and particular some of the student doing project in they want to for particular invention some new innovative thing they have to find out in that particular there is a particular patent you can that particular uh, file in some of the application just like for the solution innovation application sometimes what happen there is an application also implemented by some of the uh, peoples just like that particular application used for that social impact and that also need to be to file that particular patent application for the patent some of the satisfaction of conditions sometimes what are the available product or what are the design available some of the that condition is not satisfy that particular product then again some of the people to finding try to find out to um, remove the lacuna of that particular technology or product and they find out particular satisfaction condition also that particular condition it will need to be patentable and finally that all related solution invention applications and some of the condition satisfaction that is all that to patentable. Now see, in Indian law and practice, particular first to file system. Now see, in our Indian patent office, first need to be file that particular patent. What are the product? What are the query or unsolved problem you have solved? Need to be to first to file in Indian patent office. That means that particular register on your name only. In Indian Patent Office in overview, just like we will see first overview in India, total four headquarters available of patent office. Just like first headquarter that is in Kolkata, second available in Mumbai, third available in Chennai, and fourth available in Delhi. People can submit their online as well as offline patent also. In before 2016, there is a only for the offline submission of patent. Now there is available online to each of the every offices and it is easy for two people to submit online application forms. If anyone having innovative idea in that and know what is that particular idea, they can approach that particular office and they can submit their patent in that particular offices online as well as offline mode. Now some of the in our India, some of the consultancy also having, also of the third party also having, they can file your patent just like as a third party. Some of the consultancy. No need to go for that third party. You directly go to website that particular Indian patent website and you can file your patent directly also. In Indian Patent Office and overview, see how this structure work in Indian Patent Office. Just like they are having for the controllers, that particular controls of handling particular in three sub members of that joint controllers, deputy controller, and assistant controller. Each of the controller, just like joint, deputy, and assistant, they can having examiners. Now see, at that time, any person to file any particular patent or new idea as a patent, that time first need to that examine that particular patent. In normal regulation portion, they submit their application forms. Some of the forms having that we will see in later what are the forms required for that need to submit at the time of patent. That undergo form some of the objectives, some of the examination reports and result. At that time, that joint controller, deputy controller, and assistant controller, they have to examine your what are the topic you have submitted. They need to find out earlier anybody submitted same topic. They provide to you for the patentability search report. If anybody submitted same topic, same for they can find out that particular. If find out and they ask to you that particular already available patent, what is new innovative idea in your that, and that particular examiner to ask that query to that particular submitted applicant. In C, in invention, just like for the what is the invention, just like the two definition having invention in as a section 21J when as per the old definition, just like invention means any new and useful. Now see, any new thing and any useful thing, that is for the as per the old definition, that is the invention. Also, it's having invention in different types, just like for the art, processes, methods, or manner of manufactures. Now see, some of the person who in good in art, they can create their own art and they can do invention particular file as a invention as a patent. Some of the processes, some of the industry processes, some of the manufacturing processes, some of the methods, some of the algorithm, also they can generate and they can file that particular patent. Machines, apparatus, or other article, just like for the we will think about that particular design patent that created for particular machineries and particular apparatus or articles, also for that particular as your invention. Substance produced by the manufacturer, just like for the substances, just like the producer, those are having producer and manufacturer, and include any new useful improvement of any them, and invention as that particular in use in as per the definition of the new, just like that particular new definition in effective after 2003. Just like invention means new product or process involving an inventive step and capable of industrial application. Now see, earlier in old definition invention having 3 to 4 methods or processes, but in new after 2003, invention means new product or process involving an inventive step and capable of industry application. Now see, now everyone want lot of people to publishing patent, but no one that patent used for the industry purpose or there is a for the as a converted as in startup. That is as per the new definition designed by the patent office to product or process involving innovative step and capable of the industrial applications. What are the product? What are the method you design that is for need to be useful for any industry to implement substitutable technology and application as per the new definition of inventions. In C, invention. What actually invention having that particular? Just like for the fundamental research, improvement on existing art, solving unsolved problem of art, unaddressed issues, and different approaches. Now see, in inventions, particularly fundamental research. Now see, what happened now in lot of students to register for the PhD and that all this research. They doing their PhD, but they can't register their what are the research they did as a patent. Actually, the gap between for that particular they don't know about the knowledge about that how to submit patent and that particulars. Now everyone know what are the PhD student doing, that what are research they doing, that is a some of the novelty having, but they can't register that particular novelty in on that patent office, and that is fundamental research. Improvement on existing art, just like suppose somebody want to for improvement what are the existing art available in that, they want to for improvement that particular art, some of the new techniques they know to what are the existing availables, that is also called the inventions. Solving of the unsolved problems, just like those are unsolved problem having, people try to find out solution of that particular problems. Some unaddressed issues also, some of the issues having some technology they can find the solution of that issues, how to remove that particular issues for that particular techniques or technology. That is also one type of a invention. And last, that is for the invention, that is your different approach. Just like you think in differently. What are the regularly going? You need to in differently think then and then, that is called as for the inventions. See, in before drafting, suppose if you want to try to file the patent or write particular patent, before drafting also you need to consider some of the points in your mind, just like what is invention. See, some of the times what happen, people don't know about what is actually invention in their particular product and particular research. Need to be to find out what is the invention of that particular research. Sometimes if the invention is patentable, also need to try find out that solution. What are the research they did? What are the invention they want to for to put as a patent? That is a really for the patentable or not. Sometimes what are the invention novel and inventive. Sometimes what happen? What are invented by that particular peoples and student, they cannot find out there is a novelty available that particular patent or not. See, if you want to find out novelty of that, you need to refer of the lot of research papers that particular things available or not. what are the literature review, what are the research done by that particular. Then and then only you can find out the novelty of that particulars. Otherwise, lot of papers doing some research and they not any novelty having their research. And particular prior art and prior disclosure, just like say prior art and disclosures, oral disclosure, prior printed publication available to public, and prior public use. Just like before drafting, you need to think about that. What are the topic you have chosen for the file the patent? Any oral disclosure available in publicly? If available, then what actually mentioned? Try to find out what are the publicly available and what are the your submitting patent. What are the difference between that particulars? You need to find out that. And suppose you want to for submit that particular any new thing you found in your research or whatever patent, then you need to justify that how better we use of that particular your things. Getting everyone? Any doubt up to this?
No, sir. Please continue.
Okay, thank you, ma'am. Now see, before drafting, again need to for the verify the some of the points, just like conduct the search. What are the drafting patent need to be conduct of the search? What are the related materials available that particular patent, just like conduct search that particular. Enlist the problem in prior art. Now see, you need to find out that particular what are the problem you want to for provide the solutions or find out that solution of that particular problem. We need to be mention one list in mention of problems in before drafting. Again for third point related, what is the problem sought to be solved by the invention? Now see, what are the problem you have to mention that particular and what is the solution available and that solution that is for your invention, how it is that is prove that it is also for that need to be find out. Then what is novelty, what novelty available in that particular patents also need to be study about that. And if the solution is obvious, just like for what are the solution you provide, what are the problem statement you have found and solution you will be provide, need to be find out there is a solution obvious, that means some of the partial solution will be provide, some of the fully state solution you provide, or some of the uh, other side solution you are providing. You need to be to find out is the artificially excluded. Now see, remember this, it is any artificial that having excluded that particulars has publication unused, just like for the in publication, just like you found some of the problem statement on the publication research paper and that, and just like you want to same put in public, that is not will be acceptable in patent office, because at that time you submit any topic that patent office to send to you particular patentability search report. What are the topic you want to submit, they find all database having database, and where is that research done, they send all the links to you. You need to justify what are different between that published patent, available patent, and your patent. Then next point related that particular as certain of the type of application whether complete or provisional is to be files. See, some of the application that is whether complete patent you want to file or just like some of the provisional is to be filed. Just like there is again two types. We will see in later that a provisional patent and that complete patent. And finally, decide area and nature of protections, just like case of conventions. What are that particulars? In you decide that particular area, what area you have choose and go to only that particular area. Because what happened now in currently, what are area you chosen, that area is connected to so many fields. You not go to for that so many fields. Only one area you find out and go to that way only. In it, all that points you need to verify before drafting any patent. And what is not patentable. Just like for the lot of list, there is no required for that in details that particular, just like previous controversy are established natural laws, scientific principle, abstract theory, you cannot claim about any scientific principle and that. New property use, known substances, marrying, arrangement, rearrangement of known device, each function independently one another, moving method of agriculture and horticultures, just like for the treatment of human beings, animals, including diagnostic methods, plants and animals, which are the part of the care. essentially biological process, mathematicals, business methods, computer programs, algorithms, methods of playing, presentation of informed type. In this, all the things you can't patentable. Just like public domain. See, what are the publicly available? Just like in publicly available, public knowledge known to person in the art, a part of mental equipment with the concern with the art under considerations. And second, that is created for the common general knowledge, all available public knowledge, and all that is published. Now see, these are public, just like all available public knowledge and all that is published. You can't publish that particulars, patent that particular. Those are available generally in publication. Just like see, in kind of publication, document papers publication should be provide unmistakable direction disclosure of the inventions. Even single disclosure is sufficient. Extent of publication, availability of publication in immaterial. What are the publications? Sometimes what are the student any published papers and algorithm that particularly they want to for file that particular algorithm through that particular publications. Now see in specification, just like patent having specification, just like for read by that patent office, license, assigning some of the code, technical peers, skill person, competitors, commercial players, and general public. See, all these specification have been patent. Just like patent office also licenses for technical peers, in competitors, your commercial players and general public. Just like the competitor. Suppose you file any product patent and your competitor, what are the related same industry that have it. They also follow your specification that particulars. Some of the commercial players and general public. That is all the specification having in patent. Kinds of specification. Now see, there is actually basically having the two type kinds of specification. First, that created provisionals, and second having the complete. In application, what are the application you want to file? Just like convention, peer, PCT, non-convention, division, and patent of addition. Just like say basically some of the papers to fill for the provisional applications to register of the patent or file the patent and some of the complete because in provisional just like they having some of the percent information just like out of 100 only having 30% information and they want to for registers that particular idea or product for in provisionally and after they given time up to 12 months or 18 months you need to submit within that and then after that particular some of the people to complete solution having they can file as a complete patent. Just like see, in pros and cons of provisional specification. In when there is an urgency, suppose any urgency you are having that time you can submit that particular provisional specification. In commercial disclosures, just like commercial, if you want to manufacture some of the commercial based product and that type use of that particular, just first to register that particular part in your provisional specification patent and after that you can commercialize and some of the people submission of thesis what are the thesis they also follow to register that particular patent just like inventor seniors leaving the companies accidental disclosure and many competitors based on many competitors they want to for register that particular product as a patent in for their particular registered industries. In provisional specification, now see, if you want to file provisional specification, each document describes the invention and need not contain claims. Now see, in provisional specification, there is an invention you put, but you did not contain any claims. You cannot claims. Disclose as much possible, just like decided date of application as a form 2 and the following specific description innovation, just like in form 2 just like some of the forms available form 1 form 2 form 8 form 28 we'll see in later what types of that forms available in form 2 you mention that particular date up to that date you can that submit the complete specifications just like see in specification can be embedded to add new information in time of filling to be completed in 12 months. Now see if provisional patent you have submitted they provide to you time up to 12 months. Up to 12 months, you provide that complete information or some of the add new features that particular patent, and within 12 months, you can submit your complete patent. If sometimes what happens, some of the industry and that it is not possible within 12 months, you can complete and to register on that particular that time. Again, they for given for the maximum 6 months time. That means total 18 months time you have in that, but that 6 months also you need to require for to find out justification why you require of the extra 6 months of that particular things. You need to justify that, then only they can extend your 6 months. In now complete specification. In C, the complete specification is the techno-legal document, just like describing and patiently claiming the invention, just like C. In complete specification, you already claim that particular. Describe what are the your legal document having that particular, and basically claiming the invention. In Form 2, the following specification particularly describe and ascertain the nature of the invention and manner in which it is to be performed. Now see, in complete patient, you need to mandatory that particular assertions, the nature of the inventions, what are the nature having that invention and manner which is to be performed. That is what are the claim you are put it in your patent. Need to be justify that in complete specifications. In specification, in specification having your description as well as claims. Just like see, patent specification in descriptions is description discuss the invention. What are the invention you want to submit? Whole description having that invention, and claim define boundary of monopoly. Just like what are the claims you want to for that particular boundary of that monopoly, up to what limit that claims you have do that particular inventions. Okay, that is for the difference between your description and claims. Now see, in complete specification also as per the section 10.4, specification shall fully and particularly describe the invention and its operation or use of method which is it is to be performed. See, remember at the complete specification, fully and particularly describe the invention and its operation. What are the specification you want to that particular product or design, whatever patent? That is a operation. What are the operation of that particular and use of that particular methods? You need to be perform all these things and disclose the best method of performing innovation which is known as the applicant for which is entitled the claim protection. Now see, in claim means just like what are the best method of that you are claiming for that particular, that is for need to be justify that by the applicant. What are the best method having that particular claiming? In description, just like we'll go to for descriptions. Description must describe the invention comprehensively. What are the description given? If you want to describe particular thing, just like for that particular description must be described invention comprehensively, should fully explain the problem to solve with example. Now see, in that description, you need to explain what are the problem having that to be solved with examples. And in that particular description, there is a no ambiguity. That is a in description you properly managed to explain what are the problem, answer problem you want to solve, and what is the methods, what are the examples, all in this way. Just like should be adequate and sufficient so that enables the person skill in art to perform and repeat an invention without inventor further input. Now see, this is important. What art should be adequate and sufficient enable person skill and art of perform and repeat the invention without inventor further inputs. They cannot take the further input that particular any inventors. What are you want to for put your idea? Complete description mandatory you need to be provide. Again, further to reflect in the invention is just like novel, inventive, industry applicable, and patentable under Indian patent law. Now see, sometimes what happens, some of the description you only mention for the novel thing and innovative thing, but you cannot mention that it is a industry applicable or patentable under the Indian patent law, because it is also need to be mentioned what are the patent law you are following that to patent that particular things. That is in mention in that particular in descriptions. See, at that time, if you want to file any patent, just like content of description, what are the field is required, just like your title, what are your title having patent, field of inventions, background of that particular invention, what are the invention you want, field, what are the field required, background of invention, just like some of the literature survey, you have did that particular inventions, need to be that background you need to mention, prior art details, some of the prior information that particulars details, objection of invention, object of invention, some of the object you need to be mentioned, statement of invention, some of statement also required at the time you filing that particular patent, and detailed description of inventions. We will go one by one what actually that particular title, field of invention, background. It's like in title C. In titles at that time to filing any patent, you need to be concentrate on your title. What are the titles you are putting? Just like C. On-site statement providing the crux of the inventions. Care should be taken to incorporate all major aspects in claim, product, process, and apparatus. Now see, these are the three major part in your for title. At that time to putting any one title for patent, that particular title related for your product base, particular process base, or apparatus base, you need to clearly mentions, because somebody suppose reading third party that particular title, they can easily get your particular title having product base, particular examiner suppose reading that, they can find out your particular patent filing that process base and apparatus base. That is for need to be mentioned clear cut title according to product, process, or apparatus base. Just like example, see that particular title in brush versus cleaning articles, and second having that pen versus writing instrument. Now see, in brush, just like for the cleaning articles in brush, and pen second for your related writing instrument. Just like if you filing patent, that is for the in related for your writing instrument. In this way, you need to justify that particular. That means what are the writing instrument you suppose mention. They can get easily what types of the your process based, product based, or apparatus based you want to submit patent. Cleaning article. Based on that, you can what are the reading that particular third party exam, they can easily got what type of having that particular titles. See, in opening description, field of the invention, just like for the more detailed than the title, what are the description at the field of the invention, second thing our field of invention, you need to provide of the more detail than the titles. What are the title you are mentioned, you need to be provide more details. They can okay, they can guess what are the title and what are the inquiry, but you need to provide of the more details for that particular descriptions. Provide utility, what are the utility having, unity provides, and sometimes use of the tools for search in the absence of abstract. Now see, you need to provide some 10 to 12 lines of the abstract, what are the idea you want to put that particular. Sometimes use some of the tools. That means some of the tools you can put that particular in, suppose your abstract is not properly you are finalizing that. Some of the tools put based on that they can search and find out what actually that particularly you want to put in idea. In third thing that is background. Now see, provide the technical background of the invention. You need to just provide the technical background. What are the technical background having that particular titles? What are the material you have collected? What are the literature survey you have did? You need to technically mention that background, what is availability of in, what is generally available, and what you want to put in new thing in that particulars. In prior art, see, sometimes required prior art, but in prior art in India is not a mandatory. Prior art just like the brief write-up of the what known before the inventions, set out the problems associated with the each of the known art and describe the problem proposed to be solved by the invention. Okay, in prior art is not mandatory for India, but suppose if you want to file any international patent, that time you need to provide of the that prior art of that particular patent. Now see, in prior art, what prior art just like for the different aspect. Now see, suppose anyone want to for to put that particular, just like the example, this circles, all that prior art that circle particularly available. You don't know about that circle of the shape and that. But same that is circle one invention provide. What are the just like for the what are the circle available? They can make the like that. Okay, that is for your inventions. That is different approach. For what are the you are available, that is for different approach that particulars. Getting everyone now see everyone that is a circle is a common in these things. But what are the that invention? What are the person want to submit their particular file, that particular circle. In this way, different approach they submit. Getting am I audible to you? Hello.
Yes, sir.
Yeah, everyone getting that particular different approach. Just like suppose already that circle shape everyone know, but some of the inventor to find out such type of that particular circle only shape is different, and they want to file that particular as a inventions. Now see, in prior art, sometimes what happen, unsolved problem. In what are the collecting of prior art, sometimes some of the applicant to find out the unsolved problem, and they want to try solution of that particular, find out the solution of that particular unsolved problems. Second thing, prior art solution not working. Suppose in prior art solution is not working, then that particular applicant to find out that solutions, how it will be work. And third thing, data about describe new solution additively. What are the solution earlier available? What that solution is using, but that applicant to find out in newly solution that is a beneficial for to all. In this way, they can find out. That is for related your prior art. Objects, in particular, object of the invention, just like provide the purpose of invention. What are the purpose having your inventions? Then main objects and ancillary object also need to be mentioned. What are your main object and ancillary? And finally, essentially aspect and the preferred optional aspect. Just like suppose sometimes what happen, essentially aspect and preferred optional. Then you need to be justify that particular aspect. That is properly to mention your objects. In statement, next field available statement of the invention, just like see statement of the invention, statement forms, and the main claims or claim in verbal agreement. Just like see what are the statement forms having, that is your main claims and claim in verbal agreement. You need to justify that, and it is essentially only when there is an omnibus claims. That time you need to require that particular in claims. See, some details of the description of invention, just like set out best mode performing the inventions, describe the invention in greater details, just like see, at that time you mention that particular invention to mention all the details, just like example related for that particular inventions, illustrations, sometimes more detailed information required, sometimes record of the tables also for that inventions, some of the graphs you required, some of the diagrams, all these manner need to be mentioned in that particular your invention description, detail description, just like diagrams, your flow charts, illustration tables, some of the formulas mandatory to mention in detail, and description sufficient to enable a skilled person to put the invention into the practice. In claims, just like in claims, the main define the essential features and the subclaim define the prefer optional additional features. At that time you want to mention any claim that particular in specification details, that time need to be mentioned that is the essential features you want to claim or some of the optional features you want to claim, that particular that is need to be mentioned properly. Sometimes what happen, those are essential features claims having, you mention only that, but what are the sub or optional features and you not mention properly or not given any justification properly. That time need to be finalized. What are the your essential features and particular having additional features of that particular related and need to be justified properly. Just like important of the main property need not to be merged into other claims. See, what are the important property having, you do not merge that particular in your other claims. And just like separate claim to be form of the important features, you can submit what are the claims you are having in the form of your important features. Sorry. In claims, also operative part of specification defines monopoly confirmed by the patent. Now see, in what are the claims? That is a monopoly confirmed by the patent. Just like define mates and bounds of the inventions at the time of infringement proceeding. Only claims will be interpreted. If you do not claim, you disclaim. See, at that time you file any patent. That time important for your claims. Just like for the at that time infringement that proceeding, only claims will be interpreted. If you do not claim, you disclaim that particulars. Do, does and don't do. Just like general expression should be substantially supported properly, the name term used should be the familiar person skill in the art. At newly coined terms, name should be clearly described. Some of the specification must be described. Invention conceptually should be explained. The problem solved fully with example. Now see, sometimes you do that particular. What are the problem you need to solve fully with examples. No ambiguity of that particular problem. I should be adequate sufficient as an enables art of perform the inventions. Now see, in drafting, at the time you want to try to drafting of that particular patent, just like fundamental research is important, just like what are the PCR technique you are using, just like patent cooperation, specification of described gender dance, approach adopted, what types of approach you have adopted to that particular inventions, detail of enabling process. Now see, it is required for the details thing, what are the enabling process having that and a best mode, how to best way that you can call that particular there is a idea is a innovative and novelty having that particular ideas. See, avoid negative example. Remember this at that time to drafting. Need to avoid the negative example because if you put a negative example, negative means just like for the you compare of the two different things. Just like for the others is a bad and you are for the good. In this way, don't put such type of a things. How your product, how your idea is a better as compared to other, you just only put. Don't blame any other processor or product. Remember these things. That is given for avoid the negative claims or examples. Just like independently word claims. See, what are the claims you are claiming that is a independently you claim. Just like easy to understand the inventions, easy to search, easy to license, and easy to establishment infringement. In this way, you can claim indefinitely all your claims. In characterization in claims, just like characterization not possible in many cases, just like need to be characterized. Even if characterized subclaim need to be the restricted to the characterized part. Now see, in characterized claim, if you suppose want to particular characters, this particular characterized, this is a difficult to claim that particular things. It is not possible in lot of cases. Verifying, see at that time drafting verifying following conduct search if the invention is patentable. See, it is need to be find out what are the you are drafting that particular it is invention patentable or not. If already patent, then your patent or idea definitely will be rejected. Has it been published? What are the patentable that is already published idea? Assertion whether complete or provisional to be filed. English problem in prior art. What is the problem solved to the solve inventions? Is the solution obvious and non-patentable items? Need to be find out. Prepare one checklist. Find out the solution of that. Justify that and then submit your patent. Again in checklist, just like in specification Indian requirements such as deposition, source and origins. See what are the source of that particular idea. Find out that. What are the origin of that? Need to be find out. Collect all details such as experiment data, example, tables and graph. And after that, draft the text. If you are having all related data, example, tables, graph, then and then only you can to start the drafting of that patent. See, decoding the examination report. Suppose patent published and decoding the examination report, just like following that particular procedures. First, you need to file that particular patent. After that, request for examination. See, after filling the request for examinations, in that particular examination, first examination report come within a 3 to 4 month. First examination FER. And after that 12 months, that particular you need to respond that particular claim. What are the objections they have taken and what are the objective you have defined, and we justify that particulars. Then discussion and hearing. After that, there is a particular hearing or what are the idea you have put it, and after that, that acceptance or rejections. See, if patent you have filed that particular, first need to be to request for examination report to examine that. What are the examiner we have seen, they can examine your that particular idea. They provide examination report to you and asking some justification. You respond within that up to within a 12 months. That means 1 year. If you not respond, they reject your patent. If you properly respond, then again discussion with you or hearing sometimes call, and finally to decide that particular accept or reject. See, just like first page of the examination report. Suppose if your examination report, first of examination report you got, just like for the what are the available the name and that, just like first examination reports, patent application numbers and that, all details that particular available. Just like for that, they send to that particular examination report to you. And objection of the examination report. See, what are the objection? They can mention in this way. Just like first objection here, claims are lacking in the novelty and inventive step in the view of cited document. What are the cited document that particular they mention number also and are not allowable in either section of the 2A, 21J of the RC. These are the objections they had taken. You need to justify that particular objection. What are the objections they taken? Second objection taken, claims for the under the 3Q of the Patent Act therefore are not allowable. You need to justify all that answer, just like claim 20, not clearly define the invoice with respect to the portion marked therein. See, what are the claims you are doing? Then properly mention or properly define. Proof of the right should be filed, necessary petitions. What are the proofs? What are you want to put your idea? Need to be provided some of the proofs. Drawing, some of the diagram having in your patent need to be that particular property draw or refer that particular, just like under number 14 patent rules amendment in 2006. Detail regarding of the applications for patent which are filed outside India time to same or substantial same invention should be furnished within 6 months or date of filling of said application clause subsection. See, sometimes what happen, what are you fill same content available outside of India patent. You need to they provide distribution of that objections. And finally, detail of regarding such and examination report including claims application allow refer to in rule of 12.3 patent rule 2003 in respect same substantial same invention filed in the major patent offices, just like for the USPTO, EPO and JPO. In that appropriate translation where applicables should be the submitted within a period of 6 months from the date of receipt, and this commission provide another sections in Indian Patent Act. See, what are the objection? In this way they provide objection report, that is examination report to you. You need to justify all that particular objections. Just like see, we claim. What are your claims? Just like a method of the outputting users. See here, this is a sample of that claim. What are you claim? A method of outputting user interface, even the third party device homework, comparing servers, client, control point within the server client are joined in UI session using remote protocol and the control point control the method comparison. Just like for the receiving UI, event message from the third party does not join in the UI session where the UI message represent the changing state of the third party device. Selecting target client processing UI event, transmitting an out session connect action messages, OS connect, requesting connection setup, third party device, select the target. This is they can mention not clear or clearly described. In this way, they can take the objection. What are the claims you have did? See, in this way, you need to put claim, but they take the objection because what are the claims you ABCD you have put it? They can't given any clear idea what your product and what you are the claim patent. Okay, in this way, they can mention that particular claims fall under the section in this way mentions and not clear the ideas and put it in one section and act and they asking the justification to you. Please describe the in properly. Now see how overcome for this objection. Suppose you got that particular objection, how to overcome that particular objections. It's like strategy and some tips, just like practice of the retaining objection international search report ISR and internet preliminary examination report. You need to refer out that what are the internationally search report having and what are the patentability report you have received to find out that particular utility invention formality leave to attorney file detailed response early as possible. Interview with examiner. What are the examiner interview with that, discuss with that, and to find out the solution of that objections. Some of the submitting expert evidence support application you. Some of the provide examiner to support application to you that related. This already published and that. Just like patentability report. You need to find out that particular. What is new thing in what is innovative in your that. Citing precedents, Indian cases, foreign cases, particular relevance. Also, you need to find out what are the foreign cases happen, what are the Indian cases happen, and need to justify that objection. Grant of the corresponding foreign applications such as US, CP, and JP. Again, seeking here in 10 days before the final date. Now, see, if there is a seeking before 10 days, you find that particular date, keeping the option open for the patent addition and divisional applicant rectifying drafting and prosecution lapse or the rule on the prosecutions. Just like appeal of that particular IPAP, just like intellectual property appeal both, and to submit your resubmit of your that particular objections. In prosecution in negotiation, just like all the ground negotiation are the applicable to the prosecutions. Now see the PCT system. The PCT system in India, just like for the Patent Cooperation Treaty, in that particular signed by India effectively December 7, 1998. About 130 countries are the member of that PCT, just like Patent Cooperation Treaty. In that particular common approach, just like your first applications, in that first application, just like refer to all that related countries, UK, USA, China, France, Japan, Korea, Italy, and Hong Kong, and they find out that particular related search informations. Why PCT is important? Just like for protection in multiple countries. Now, see, it is a protection in multiple countries. If patent has inherent merit, PCT is the answer. What are the PCT? They can the answer of that particular objection. PCT is not the international patent. Remember these things. This for only on the Indian body. See what is PCT? PCT is just like window through which an applicant can file single patent application and secure priority in the designated state procedure. What are the designated state procedure having? They can secure their application through that particular patent filing application. And search report that evaluate the invention. What are the search report they got? When evaluate based on that, they can find out the invention. And finally, to examination report to submit. There is optional for that in PCT. How to file PCT application? Just like say, an applicant may file PCT application in the designation National Patent Offices and PCT headquarters. You can see the procedure of that particular PCT also. In month of filing priority, founding application filing international application 12 months, search report for the 6 months, amended in the response 16, and publication of application that is for the 18 month required for that particular. In this way, they can take the time. Then national law of the concerned state that takes over and eventually patent is granted. Now see after that they can grant that particular patent. What are the according to for their national laws. In but Budapest Treaty, just like Indian signed by the treaty 70 December 2001, in that particular Budapest Treaty, deposition of the microorganism for the purpose of the patent are made available to public after the grant. See what are the they can particular what are the protocol that having they can available publicly after the grant only, not after publishings. They having international recognized depository and that is available in MTech Chandigarh in our India. Okay, this is a part first for related for that how to submit that particular patent. Second part related for that particular having how your intellectual property management for startup, how to use for your IP for startup based. Just like see in that spotlight in knowledge in today economy. What are the today economy having just like related for knowledge, weightless, information digital, service economic factor of that particular production. Just like see in suppose if you want to product particular material and that is related for that particular land, label, capital you require, and knowledge as a useful information. information as a public good and information as a property. Now see what are that particular available in factors of production, useful, publicly good, and that information as a property. Now in market oriented economy, just like playing fields, what are the playing fields available? Unfair competition, free riding in market. Suppose what are the product you are having, you suppose register as a patent, but again for need to be for two, there is a unfair competition in market. National legacy system diversity, bilateral, regionally, international treaties or agreement. After that particular adding value, if your particular product is provisionally patent, in adding value of that, meeting exceeding market and need to expectations, market research, consumer needs, what are the consumer needs, competing products and substitute gaps, technological innovation as an sorry, technological innovation as an element of the marketing. Now see, what are the that particular IP patent having? You need to that particular emotions that particular element as a marketing. That is also challenges in your startup. Now see, in adding value in today economy, just like raw materials, value addition, price, individual enterprises, ownership, and value addition. Just like all these are the factors having in your startup. That is you need to register for that particular product as a newer startup. In individual also there is a chain of networks having in multiple ways. Just like customer that what are the customer that particular performance is, just like time data performance, what are expectation of that particular continuously improvement of that particular product, what are the product on that, and that you can find out that particular performance gap and need to try to give the proper solution of the customer what actually their requirement and what they want actually. Just like see, tangible and intangible assets, you don't know about that particular tangible. Just like intangible, different from the two ways change the rules of the game. If not game itself, value in the contents and multiple simultaneously value stream. Just like see, level of product. Suppose you are having product just like core benefit of services. That particular services actual product that having the quality levels, brand name, packaging, features, and design and your core that particular core related services just like for the augmented product just like augmented product having installations after sales service and delivery and credit and what are the warranty of that related, that is for the multiple types of products available. That means after you start particular register your product and to start the startup you need to face all these particular created product, core product, actual product and your augmented products. Now see, in your tangibility spectrum, tangible and intangible, just like salt, soft drink, detergent, automobiles, cosmetic, fast food, these are all for your tangible spectrum. And your fast food, advertising agency, instrumental, consultancy, teaching, that is intangible domain. Need to be face all these system of a spectrums. In strategic entrepreneurship and innovation. Now see, in first entrepreneurship is concerned with discovery of the profitable opportunity. See, at the time if you want to start any entrepreneurship, need to be discover profitable opportunity. What types of profitable opportunity having need to be find out that. Exploration of the profitable opportunity to export, explore that particular profitable opportunities. Themes that encourage entrepreneurship are just like for the risk takers, commitment to the emotions, and proactive in the creating opportunities rather than the waiting to respond to the opportunity created by the others. Now see that is important. What are that particular proactive creating opportunities rather than waiting to respond to opportunity created by the others? The process of step of innovation. Now see, understand the process of innovation. Just like suppose if you want to try to start the startup, just like for the process, what are the idea having that? Just like your ideas, experimental research and business plan of the concept just to be put. Then what are the seed that particular? Just like for the legal entities, founders, management teams, minimal revenue and the slow growth. Again, for the startup, if you want to start particular startup of that, support functions, administrations, marketing, and revenue growth also need to be think about all that startup. What are the support function and their startup? Administrations. What are the administration follows? Marketing strategy and revenue growth. Expansion. Suppose if you future, if you want to expand that particular high growth head count and multiple cycles. And pre-IPO, just like for the visible market acceptance, heading of the IPO and marketing and analysis that particulars. This is the process of that innovations. And need to each state. What is you required for the each state? Just idea concept, business plan, prototype, project management you want, business premises, project management, and management training. All these are required for the particular ideas. Second, seeds. Just like this is for related IP. Earlier slide we have seen just like basic process. This is for need for the state of the your IP management in all the stages. In seed required corporate and secretary, financials, training, PR and marketing networking, business development. Startup, recruitment, business development, AMP and market access. And finally, expansion you required in IP management, international support, market access, diversification strategies and support, recruitment and training and incentives. See here, particular understanding the business and role of IP. Just like the if you patent that particulars, you need to manufacture that particular. After that, you distributions, then sales that particular product, and finally brand. Just like understanding the value of the chain business and industry. What are that particular value having that particular business and industry? Understand how profit are generated. Need to be find out how profit generated. Primary product, spare parts and related product, and service and maintenance. What are the important features of the IP? Just how does it add value to the businesses? You need to find out that particular how it could be add value in business and what are the important features industry other than IP, just like other important tangible, intangible assets, value chain, competitive structure of the industries, customer characteristics, then substitute product. These are all related for the industry other than the IPs. Now see, just like we bring the one example, that particular example, Coca-Cola. Just like decades ago, Coca-Cola decided to keep the soft drink formula as a secret. The formula is only know about the few people within the companies. Kept in vault of the bank in Atlanta. Those who are know the secret formula have signed non-disclosure agreement. See, it is rumored that they are not allowed to travel together. And if had patent, then for the whole world will be the making Coca-Cola. Just like see, this is one example for that bringing all this together. Those are person no secret formula to making a Coca-Cola. They have to keep to each other's. Second example related for just like Lego. Just like for dated Lego patent for stud and tube coupling system. Just like we have bricks sold together. But today the patent have long expired and the company try to hard keep to our competitor by using design, trademark and your copyrights. Third example that is related for your pen. Just like in patent for the fountain pen that could store ink. Now see first example that is just like fountain pen could store the ink. Second, utility patent. Suppose you want a utility patent, utility model you can create just like grip and pit injection of the ink. Grip you can put it on that particular in this way and utility pattern. Industry design. Suppose you want the industry design just like smart design with the grip in the shape of an arrow. What are they having? That is shape. It is industry design. It will make that particular pen. And finally trademark just like provide the product and the packaging to discussing of the other pens. See, just like they provide the trademark of that particular product. Just like firstly they find out that particular paints and they can patent. After that they utility model they can create it. Then after that industrial design they can make paint and finally to trademark just like for the some of the symbol on that particular paint. Just like again another example Nescafe. Same that is for registered trademark as a TM unregisters. Now see, register design, copyright labels, artwork. What are that particular artwork, that particular symbol and that they can register as a label and artworks. And finally, patent of the several dozens. Now see, in your startup, IP management in startup, just like IP adds the value every stage and value chain from the creative innovative ideas to putting in new better and cheaper product services on the market. Just like see, what are that particular patent? Just like your invention ideas here. Invention idea having patent utility model trade secret. and your that particular library restrict creation, copyright related rights. Just like after that is starter, you need to give the particular finance, just like patent and utility models in cover here. Again for industrial design, trademark and GI, you want to for that product design in this side. And that particular after next page that is a commercial marketing and licensing, you want that particular trademark, GI, industrial design and patent and copyright created for it that particular inventor only. And finally all IP rights created for the exporting. What are the IP? That means how that particular IP registered product in the market chain will be expanded, just like related invention and libraries, financial, product design, commercial marketing, licensing, and finally exporting. In this way, they can form the chain of that particulars. And I think, thank you. Okay, any question related for that?
Yes, everyone. Anyone have any questions?
Okay, I want to share with that particular forms and that. My screen visible? Hello, my screen is visible.
Yes, sir. Your screen is visible.
Yeah. Okay, see here. Just like for this is one example, that's for a patent dated for say, just like this is particular forms having form 1, form 9, form 18, form 28, what are the that particular, just like see complete specification of form 2. What are the form 2 available? Need to be complete specification, just like see here. At the form that particular, just like Patent Act 97, the title of having is system and the method for the detecting gas leakage. Okay, as per the patent name, just like our university mandatory VAT, that is the first name and after that our. Just like specification C, how to that particular preamble the description, complete specification. Just like C, title is having the system and the method for detecting gas leakage. Just like complete specification given in that particular field invention, just like 001 present disclosure related generally field of gas detection and safety system, in particularly present disclosure patent system method detecting gas data background. Just like find to out what are the background having. Lot of system having to find out that gas leakage and that. But no want to find that particularly to send message that particular users in mine patent. Just like same that is I have seen that particular message that particular owners that I have put it here. The background put it see how to systematically write that particular drafting 002 case what happened 003 in this all that mention properly objects how to object mention of that particular present disclosure. See some of the object present disclosure which is at least embedded here me circle is below object at LPG leak object is the present disclosure to real-time detections LPG ensures that and finally summary is given that particular related things. After that, brief description of drawing. What are the diagrams having that particular what are particular patent? That diagram figure 1, what figure 2, figure 3 illustrate block diagram of proposed systems accordant with the embedded present disclosures, then detailed description and of the present disclosure. What are the present having that detailed description of that present disclosure also in this manner. And finally then see here, this is the total detailed description of that particular patent. And finally, advantage of the patent disclosure. What is the advantage that need to be mentioned there? And what are the claims? Now see, what are claims? I have a system for detecting gas line system compromise, microcontroller. What are the IoT devices including couples of that memory 106? That is for the diagram numbers 106, 106. Continuously monitor gas detector and equip one of the semiconductor one more sensors. Predefine area gas detector receive the alarm unit signal from detector. In this way, we need to claim just like what are the point having that particular claims in this way. We need to claim all that points. Okay, this is for rated. Then drawings. See what are the drawings having. We need to separate page that drawing just like for C systems microcontroller 102, 104. We need to draw in separate. All this for related for that diagrams. Then form number 1. Just like see this is for the title is given that particular related and inventor names all related for that particular and description. sign of that particular when that file and that, and finally all details. How many complete specification, number of pages 18, number of claims 10 2, abstract 1 page, drawing for the number of pages 3, number of drawing 3. In this way you need to complete specification need to be provided. Form number 9. What are the form number 9, 18 that created for your fees and that outline all available that particular, just like what are the fees and that created available. And form number 18 and 28 same dated, that is a after you are submitting that claiming and that proof submitted to the Educational Institute, just like that forms. In this way you need to mention all this that particular, and after that field you got the official receipt also, just like for the 392 and 23 what are having that particulars. And CL, patentability search report. At the time I have submitted that patent, they send me patentability report. Such type of a patentability report having. See, search objective, understanding matters, research methodology, database, Indian prior art, summary and submissions. Just like see, search objective, understanding subject matters. Then research methodology. We need to mention the method, determine novel feature, disclose submatters based on subject matter reference section 4, identify appropriate patent, then framing of the inactive search strategies, report preparations, database. Suppose requires a particular database where you collect that particular materials of that particular database also need to be given. Non-patent database also need to be mentioned, just like Science, Directory, Google Scholar, Python Explorer, and PDF. And finally, see patentability report they can change. Suppose what are the topic I have submitted, prior art reference. What are that particulars? Already long alarm device, petroleum gas, you publish already 90. They provide such type of a report, and we need to justify what is the difference from this patent and your patent. You need to justify that all. They provide abstract too also, patentability report. Second thing, related for the same diagrams and all these things. See, they provide that. Second, reference they provide LPG gas detector system in 2019 also. They also provide me that. I need to give that particular justification of this also. What is availability of different from compared to this patent. And finally, third, that is a non-patent heritage. IoT has to be the system is clear metal. Non-patent also they can say, and we need to justify all that reports. In this way, they can say all related patentability report. What are the list of softwares and hardware required? Also, they can mention that is particularly. Okay. Any queries from your side? My side is over.
Yes, sir.
Yes. Anyone have any doubt?
No, no.
Okay, sir. Okay. After the conclusion, please everyone switch on your camera. So I want on behalf of computer department, on behalf of computer department and IIC MMIT Pune, I want to thank you, Dr. Anil Turukmane sir, for sharing his knowledge about the content and drafting of patent application and the other topic that is IP management for startup. I want to thank you, our management and principal, for giving this opportunity to conduct this workshop, which is very much useful. And I thank all the participants to actively participate into the workshop and get the benefit of this workshop. So please switch on your camera, everyone, so that we can conclude the this one day workshop on the IP management and for startup of IPR. Seven, seven. Okay, sir. Thank you, everyone.
Yeah. Thank you. Thank you to all.
Thank
Thank
you.
you, sir.
Yeah. Thank you. Thank you to all.
Yes, participants, you can leave the workshop session.